Welcome, everybody. My name is Andres Vjovic, and I'll make a short introduction to our incredible guest, Artin. This topic is about how to navigate these new Texas law changes called SB 140, how to stay compliant, how to avoid lawsuit, while you still have opportunity to maximize text marketing. So this is a free webinar hosted by Referrizer with expert legal insights. Now, let's dive into it. Today, what you're going to learn is what is this SB 140 and how can this impact your business? Like, why should I even listen to? And then what do you need to do to stay compliant? And we'll tell you, either if you're a Referrizer client or not, and listening to this for the first time, how Referrizer manages your compliance. Now, let me start by giving you what's going on. As the partners in this seamless customer outreach, we wanted to red flag latest Texas updates, telemarketing laws. They're under Senate Bill 140, SB 140, which kicked in September 1st, so it's already 11 days ago. This bill expands Chapter 302, the Business and Commerce Code, to treat texting just like a phone calls for soliciting purposes, and adding requirements like business registration and disclosures to keep things transparent and customer friendly. Now, it is very important, guys, that you review the law to determine if this applies to your business. I shared some of the resources here as well. This presentation will be recorded and sent to you as well as a part of the recording. But I included law articles that are official documents that you guys can take a look, and the amendments to the law that went into effect on September 1st, SB 140. So it's all here. If you love to study, by all means. Now, why are we doing this? If you don't do this, you might find yourself paying big bills. There's a high cost of non-compliance. Ignore SMS regulation can lead to severe consequences that go beyond a simple warning, right? Financial penalties. Did you know that it can range between $500 and $1,500 per single text message? So you send 500 text messages to people who didn't like it, can result in what, about $750,000 lawsuit? Civil penalties, add on top of that $5,000, costly lawsuits, just fighting this. Then we're not going to talk about brand, reputation damage. And what about no-fly zone? What about banning you from texting permanently? That's even worse. So the reason why I'm saying this as a first slide is, let's pay attention, guys. We provided here education so you can prevent consequences. Now, let me make a quick introduction. My name is Andres Vjovic, for you who don't know me. I'm a CEO and founder behind the Referrizer. And my passion is always to deliver incredible cutting-edge marketing tool that can help businesses increase memberships. And I'm going to keep everybody muted temporarily. So if you can mute yourself, guys, as well. Now, we also have incredible guests, guys. Artin Betpera is a shareholder at Buchalter. Artin has extensive experience representing a diverse range of companies in complex action cases across the country alleging violations of the TCPA, called Telephone Consumer Protection Act, and related state laws. He participated in this ecosystem of SMS advertising and leverages his years of litigation experiences into trenches of providing practical advice and guidance to companies seeking to navigate the minefield of SMS legal compliance. Artur, I gotta say, it's my honor and privilege to have you here on the call and for you to share resources, understanding, knowledge with people we have on the call. So welcome to the call, Artin.
Thank you very much, Andre. It's great to be here. Thank you, everyone, for joining. I have, just as a bit of background, as Andre mentioned, I've basically been living, eating, and breathing the Telephone Consumer Protection Act and related state regulations on marketing calls and text messages for the better part of 8 years now. Typically, it encompasses about 70–80% of my practice, and I do work a lot with platforms and their clients in both kind of assisting on the front end with guidance on compliance matters. And then when, the proverbial, what hits the fan, my main kind of practice is litigation. And so I defend companies mostly in class action cases involving violations of these laws because most of the cases are filed as these, seemingly large class actions, and try to navigate businesses through those sorts of legal exposures in the most cost-effective and efficient way possible. So today, as Andre mentioned, we're going to be talking about a recent change in the law in Texas, kind of go over what the requirements are, different issues, dive into some of the nuances. Obviously this isn't legal advice, but it is intended to kind of give you a little bit more information about the lay of the land and give you some food for thought as to what you could or should be doing in response to these amendments in Texas.
Awesome. Artin, I think you have mouse control over the slide, so
Right.
let me know if that works.
Let's see here. Let's make sure. All right, perfect. All right. So in the grand scheme of things, you know, between kind of federal and state regulation, at the very top, kind of encompassing the entire country, is the Federal Telephone Consumer Protection Act, right? Which essentially, without diving into the very kind of intricacies of the law, for text messaging, for SMS marketing, basically requires you to obtain folks' written consent in order to text them for marketing or solicitation purposes, and it requires you to honor opt-outs, basically. In other words, revocation of their consent. Generally speaking, if you are doing those two things, which is really kind of the basic block and tackle of SMS compliance, you should be in relatively good shape. Now, obviously, there's other requirements under the law, but at its core, it really comes down to consent, permission, right? And similar to the TCPA, Texas's own regulations on what was originally telephone calls and now has been broadly expanded to text messages, what is intended to curb unwanted and unauthorized text messaging, right? That's the whole stated purpose behind this law. The legislators in Texas that passed the original law, as well as these amendments, really were focused on tamping down and regulating unwanted and unauthorized messages. Okay. So before this statute was passed, the Texas law did apply in part to SMS messages, but now there's basically been a wholesale application of all the different regulations in the Texas law to text messaging. And I think that the most important one for businesses has been this whole registration requirement. Okay. Let's see. Okay, great. All right. So there's kind of two things we'll talk about here. Number one is going to be the registration requirement and potential exceptions to that requirement. And then we'll also talk about some of the other like little requirements that have now been added on to SMS messaging too, which you should consider in determining how you deal with this particular statute, okay? And while I really wish in this particular instance there was a clear-cut answer to all of this. But as you'll see, as I kind of go through the different issues and talk about the different nuances here, this is really, in my view, a matter of understanding, balancing, and reacting appropriately to the different legal risks associated with options that are available to businesses uh, trying to grapple with what to do with the law. Okay. So to kind of start with, originally when we started talking about the statute, when I started to talk about the statute to different businesses, different e-commerce businesses, businesses in the health and wellness and fitness space included, the conversation really revolved around, hey, do I really have to post this bond in Texas, right? And it quickly turned into, okay, that's actually the easiest part of this whole thing. Okay. What is really, I think, viewed by many businesses as onerous and invasive is another word I've had businesses, the business owners have used to describe these registration requirements, okay, that's really where a lot of the burden and issues lie, okay? Because in order to register as a telemarketer in Texas, right, which in and of itself is a bit of a square peg round hole. You're like, I'm a gym, or I sell supplements, or I sell, whatever it might be. Like, I'm not telemarketing. I'm just texting people who have signed up to receive text from me. So why should I be considered a telemarketer, and why should I have to register, right? And that kind of irony, or kind of that lack of fit between what is going on and what the law, at least on its face, requires is really pronounced once you start taking a look through all the different types of information you have to disclose in order to register as a telemarketer in the state of Texas, right? So let's just start, okay? You need to provide the name, the personal residence address, and the date of birth of every one of the officers and directors or owners of your company. Okay. You got to give bylaws or governing documents. Okay. No big deal. Generally speaking, a lot of times those are just public record anyways, like your articles of incorporation. Fine. Your physical location, company street address. Every single number you're using to telephone number that you're using for outbound telephone or text message marketing. Okay, the name and private residence address of all your salespeople, okay, plus the criminal, civil litigation, bankruptcy history of every officer, director, and any other person in charge of any of the locations of your businesses. All has to be disclosed. Now, granted, all that stuff is a matter of public record, but you're basically putting that all into one form and handing it over to the state government of Texas in a document that, as I point out kind of below, is becomes a part of public record, right? You then also need to provide what many view as private, sensitive, potentially proprietary wage information about your salespeople. You have to provide information about where you bank, right? And what your accounts are. You need to provide a description of everything you're selling and all of the sales literature you have associated with every single one of those products. And you need to identify, to the extent you're selling goods, the manufacturer of the products. Okay. So it's a lot, right? So when you compare that to, I got to pay $200 registration fee and a 10K bond, that's the easy part. The hard part is grappling with, do I need to actually furnish this information to the state government of Texas and um, and make this all kind of these potentially sensitive, confidential, potentially proprietary information and records of my company a matter of public record, right? So that's where a lot of businesses have viewed this as a big deal in trying to navigate through what to do in response. Okay. In addition to that, let me go back. Okay. There are also disclosure requirements that apply. I just got a question which I'll answer right now. We have to pay $10,000 to register. It's actually, you don't have to pay 10K to register. It's a $200 fee, and you have to post a $10,000 bond. That really requires you to get with the bonding company, and I understand it's like a few $100s a year in order to pay for and renew a bond. Okay, but I just wanted, I just popped up, and it's relevant. So, but I'll take the rest of the questions at the end. Um, there's also disclosure requirements that, at least on the face of the statute, seem to apply to every text message that you send now, because this was kind of like a blunt force, um, a blunt force application of rules that were originally designed for telephone calls to text messages, right? And so those, like, originally telephone call rules would require anyone who picked up the phone and is talking to someone live to provide the street address of the location of where the salesperson is calling from. And if that's different from where the company's located, the street address of the company's principal location, right? And there's other disclosures that may apply depending, excuse me, on the content of the telephone solicitation. But here's the main point, is that when you apply that to SMS messaging, all of a sudden you're going from a tight, single SMS message that is focused on what you're trying to sell or promote, to a bunch of other stuff that really, I would assume or imagine, distracts from the message that you're actually trying to send to people, like with all this address information or whatever the case may be. And the issue becomes that when you go to kind of keep in mind, like when you go and register, it is almost like you're basically raising your hand and you're saying, I am a telemarketer and I am subject to these rules and I must comply with them because I have no exception. Okay. So I guess it's important to kind of keep in mind that yes, like on its face, the the require like this law applies to people who are texting. So if Texas is a big state for you, you do a lot there, then on its face, this statute requires you to go through these processes and comply with these rules unless there is some kind of exception that would apply. Okay. So let's get to those exceptions. Um, Okay. Actually, before I get to that, let me talk about the risks here of violating the statute, which Andre did cover at the outset, right? But here is kind of the big picture. If you don't register, and if these provisions apply, and if you don't have an exception, um, then you could potentially be subject to penalties on a per text message basis that are in the thousands of dollars. Okay. And so aggregated across like a class action, that could present some very serious liability and exposure for companies. Okay. There's also an attorney's fees provision. So I think I don't have a crystal ball, but what I can say is that because there is a private right of action, because it calls for statutory damages, because it has attorney's fees that are recoverable by the plaintiff, the one guarantee I can make is that there will be a ton of lawsuits, right? If it hasn't already started, there will be a significant increase in lawsuits. And the reason I say this is because we've seen it before. We see it with the TCPA day after day, right? Thousands and thousands of lawsuits filed per year. And anytime there's a change like this to a law that allows plaintiffs to recover statutory damages without having to show any sort of actual harm or damage, and especially when there's attorney's fees, that is like red meat to the plaintiff's bar. Okay. So we can expect that there's going to be potentially a deluge of lawsuits in Texas arising out of these extended requirements. Okay. So now that we've gone through all the doom and gloom of this, let's talk about, hey, is there any sort of exceptions that might apply to me? And I'm just taking this kind of in the context of, health, wellness, fitness, and just kind of e-commerce in general, as far as what potential exceptions you could consider exploring as far as, hey, maybe this applies to me, or maybe at least there's some argument to be made that I am covered under this exception that will help mitigate against all that legal risk of not registering, right? I think off the bat, some of the easy ones, people selling food. So if you're out there and basically I had a company I advised the other day, they sell protein bars. That's all they sell. And so that was pretty much a no-brainer for that company because like, well, protein bars are a food, generally speaking. Supplements become a bit of a grayer area. But that was an easy one, right? So if that applies to you, then okay, you can check that box and at least have some measure of comfort that there is an exception out there that might apply to you. The other one is publicly traded companies or affiliates of the publicly traded company, right? Had a very easy conversation with a client the other day. Basically, they were a part of, they were recently acquired by a publicly traded company, and now we're an affiliate of that publicly traded company. Easy answer. Boom. You are accepted from those rules. Okay. Another one is texts by a company, you've used the same name for the past 2 years, and you sell a majority of your goods out of a physical location. Okay, so say for instance, like all you basically you're operating a gym, you're operating a studio, right? And you basically give all of your services at a physical location. You've had the same name for the past 2 years, and a majority of your revenue is derived from your brick and mortar operations. Okay. That is another exception that would seem likely to apply in your particular situation, right? And each of these, like your decision or examination of whether or not they apply, I'm just kind of using some examples here. Really, before you make a decision, I think it's wise to consult with someone with expertise in this area to really kind of vet the kind of with all contexts, all the necessary facts, so you can get a more reasoned kind of decision as to whether or not these exceptions would apply to you. But I'm just kind of flagging these as a, hey, here's kind of some food for thought here as to potential exceptions. Now, where we get into more of a potential gray area is with texts sent by companies that have used the same name for the past 2 years, okay, that are only being made to former or current customers. All right. So, customers is the key word here. And what is a customer? Is the question many of us have been asking and grappling with. Okay, I think the no-brainer is someone who's like bought something from you. They paid you for some kind of product that you sell or a class that you have. They've either done it recently or in the past. And they've given you consent. They've opted in, right? Because we always want to make sure that no matter what, that we are only texting people with an opt-in. I'll kind of talk about the importance of that in a little bit. But if they check those boxes, then I think you can feel reasonably comfortable that if you're only texting people who've actually like had a transaction with you, that those people are definitely customers. Where the gray is whether or not someone who's like come to your store or come to your location or come to your website and has been presented with an opportunity to sign up to receive information, news, and promotional offer about your goods or services because ostensibly they are interested in buying them from you, and they have affirmatively signed up, whether or not that person can be considered a customer. Usually, when a legislature writes a carve out to a law that revolves around the meaning of a specific term, it's very common for them to put a definition on that term, right? And the Texas state legislature, whether they knew it or not, like they just didn't do it in this particular case. And so, what will inevitably happen is that some defendant is going to get sued in Texas, and they're going to make this art, they're going to present this issue to a court. And a court is then going to have to decide what the legislature meant when they used the word customer. Okay. And so how this generally plays out is that when a word in a statute isn't defined, courts will use what we lawyers call the canons of statutory construction, right? And these are just it's kind of like a waterfall of rules a court will use in order to determine what a legislature meant by an undefined word in a statute. Okay, and in this case, the number one rule the starting point for the analysis is going to be what is the common meaning of the term customer? Okay, is it someone who's bought something from you, or can it include someone who's come to your store and is interested in buying something from you? I think in common parlance, which is generally speaking, again, where that analysis will start for the court, if you say, for instance, if you've got a brick and mortar and someone walks in your door, right, and starts looking around at the products on your shelf, it would seem natural to refer to that person as a customer. Like, for instance, like, hey, I just had a customer, you're on the phone. Hey, I got to talk to you later. I just had a customer walk in the door, right? People would know what you're talking about and would not necessarily presume that that person has in fact purchased something from you, right? It can also mean in common speak, um, someone who is interested in making a purchase from you, right? But again, like I would say at best gray. I would say that TBD in terms of what a court will do with it. As a lawyer, I can say I would be, I think I would have if I had that case, I would feel that I have a reasonable argument to make on behalf of my client that the customer exception would extend to situations where like someone has come to your store, looked around, specifically signed up to receive messages because they're interested in making a purchase from you, whether at that time or in the future, right? But I don't have a crystal ball. And so I can't say what a court's going to do, but what I can say is that most likely this is eventually going to get in front of some court in Texas. And then we will really have I would say better um, like data, right? So better kind of points of information that will tell us whether or not or how far that customer exception extends. For now, we can just kind of like analyze it based on these basic rules and say, yeah, I mean, it doesn't seem outlandish to say that a customer would include someone who's like visited your store and is interested in buying something from you and has specifically signed up to receive news, information, promos via text message. Okay. So we can definitely, this is a conversation that I can probably take another 2 hours going through, right? Kind of talking about what might happen and the ins and outs. But this is really for the purpose of kind of flagging, hey, here are the things that other businesses that we've been talking to have been considering as far as, hey, are we accepted, right? And some of this also is philosophically like about your risk tolerances as a business too. Some of this also is more holistically like how big of a market is Texas for you? How important is this audience, right? There's just a lot of nuance here in navigating these rules. But big picture wise, right? We talked about does an exception apply, right? And you're trying to look through in this analysis and be like, okay, do I have anything that I can put on as a potential layer of armor here to help mitigate the risk, right? If I decide that, for instance, in my view, I'm not comfortable at this point in time registering, right? That I want to see if there's I want to look at what are my risks if I don't register and I just keep doing what I'm doing. Okay, what happens then? And what might there be out there to protect me in the event that I'm sued, right, for this? And I think again, number one, the first thing you look at potential applicability of an exception, right? And that might present a layer of armor for you. I would say more holistically, and this is applies to both Texas and any other statute SMS practices intersect with, is when the consumers are opting in, are you also requiring them to accept your terms of service? Okay. This is a loaded question because it involves a lot of different considerations, like what language are you using? How are you disclosing the fact that they're also agreeing to terms? Are you hyperlinking those terms? What color are you using for the hyperlink font? Are you underlining it? Are you using all caps? Where is it placed in relation to the button the users have to click to like submit their registration, for instance, right? There's multiples of these considerations, and I have litigated these cases a lot. I've defended, I have enforced terms that consumers have accepted in that sort of digital environment. But this is one thing you want to take a look at. Like, are they accepting terms? And then do my terms have an arbitration provision and class action waiver? Okay. And why is this important? This is important because it helps reduce the risk of a large, expensive to defend, and potentially catastrophic class action. Okay. For me, again, because I spend most of my time in the trenches defending these large, scary class actions, one of the main things when I'm advising on the front end is to look at this issue. Because if you can avoid that, okay, and if you can really mitigate the risk of these big lawsuits, then what you're left with is one-off, two-off cases. And yeah, maybe they can be somewhat substantial, but they don't present like an existential crisis to your company. Okay. And for me, if we're going back to the armor analogy, right, those terms, the arbitration provisions, the class action waivers are another layer of armor that you can put on in dealing with the issues, the risk that is now posed by these wacky amendments to Texas's telemarketing law. Okay. Now, there are trade. There's a like this is not the end of the story. okay? Because there are challenges that have now been presented to the constitutionality of the Texas amendments. And so this trade industry organization, you can Google them. They got a blog. You can follow them. You can even consider joining them. I think they do a lot of good work. They're called the E-commerce Innovators Alliance. In addition to other plaintiffs, including like an e-commerce brand and another platform, have filed a lawsuit challenging the constitutionality of the amendments as an unreasonable restriction on commercial speech in violation of the First Amendment. Okay. There was a motion for a preliminary injunction to prohibit the state of Texas from enforcing the law that was filed on September 9th. It's probably going to take at least a few months to get briefed and argued and decided by the court. But we also now have the validity of the amendment itself hanging in the balance of the as this particular lawsuit makes its way through the district court in Texas and in the federal court in Texas. Okay, so the current state of the law is going to morph. It's going to change, both based on this particular challenge, as well as the developments we will see as these lawsuits start to get filed in the state of Texas. Okay. Um, so I think when I kind of take a look at, actually, let me go back. When I take a look at this in a holistic way, in a big picture, it's really viewed as on a spectrum, okay? And that spectrum is really kind of a function of like unique uh like business specific considerations around legal risk tolerances, the importance of Texas as a market, the size of your audience there, et cetera. Okay. So on one end of the spectrum, we have basically strict compliance. We're going to kind of say, yep, this law applies, and we're going to go ahead and register. We're going to provide all that information. We are going to, put up the bond. We are going to comply with the disclosure requirements. We're going to follow every letter of the law because, we're not comfortable with either the gray areas of the exception or we just don't think they apply. Okay. So that's kind of option number one. Okay. Here on this end of the spectrum, where you find, uh, potentially more legal risk, and particularly as far as like a class action case is concerned, is what I think some businesses have kind of described as a wait and see approach. Is that we're going to, we feel kind of comfortable with this gray area of some of these exceptions. Like we've been here before. We've had, if kind of heard some other business owners say, like, look, if we strictly complied with every single law that's out there, then we wouldn't be able to do business. And obviously, I am by no means encouraging or recommending to anyone that they not follow the law. Okay. But this is just kind of, just practical considerations that a lot of non-lawyer business owners like will take and are kind of looking at, right? So over here, it's kind of that wait and see approach is that we're going to keep on keeping on. We understand that, hey, some of these exceptions might apply, and we're going to wait and see how this all plays out, okay, before we make that decision to register. Somewhere in the middle, again, really driven by where Texas lands as far as it's important to your business. Okay, is all right, well, we have this customer exception out here. There is a rather kind of concrete aspect to it, and there's a gray aspect to it, right? The concrete aspect really is going to be people who've actually bought stuff from you, okay? And we're going to say, like, look, here's our customer list. Here's all the folks who've actually transacted business with us in the state of Texas. And again, it applies to both current and former customers, so prior purchases are fine. The law, at least on its face, does not provide a time limit to how far back you can go for former customers. So if you have on your SMS list, right, check one, we have an opt-in, check two, Texas resident, check three, they've made a purchase from us. You can basically say like, okay, we're going to put these like in the green light bucket. And then you're like, what do we do with everyone else? Right? I think some of the problem lies in trying to figure out how to exactly pinpoint how how to kind of segregate out people who actually live in Texas that are on your SMS list that haven't made a purchase from you in the past. And there's really kind of a couple ways businesses have weighed. It's like, okay, do we use IP geolocation? Do we use area codes, right? And so we've had a lot of discussion about area codes. Again, not perfect. None of this is, right? It's a net you cast and it's going to have some holes in it, okay? But I think for me, the area code, if I'm putting on my lawyer hat, if I am if I'm basically saying that I'm going to take people who have actually done business with me in the state of Texas. And I'm going to exclude everyone else with a Texas area code who may have signed up to receive messages from me, but I don't have a purchase history for. That's kind of like an interim measure as you kind of see how this all plays out. The benefit of taking that approach generally is that it is likely that it will, unless you are based in Texas, it will hopefully keep you out of a lawsuit in Texas because there's a whole concept of jurisdiction, basically that if you're not like actually based in Texas, the plaintiff who's suing you in Texas has to prove to the court that you have done something like knowingly directed wrongful conduct into the state of Texas. And in the context of SMS messaging, the main hook that the plaintiffs have is that you have texted a Texas area code, so you should have known that you're sending this unauthorized message or unregistered, whatever it may be, into the state of Texas. What excluding the kind of fringe benefit of excluding Texas area codes, if you kind of take this middle ground approach, is that you will likely or have a good possibility of avoiding being sued in Texas. Then you've got kind of this home court advantage where people have to come to your state and sue you where you're located, or even if you're international, that's a whole other kind of different analysis there. But that is, to me, always a benefit that like you can avoid being drug out to Texas to have to defend one of these suits. And there's other kind of nuances there. Once you get out of Texas and you're in your home state, then you have issues like, okay, well, which state's laws apply in this situation, right? You basically end up, in my view, kind of making yourself into a bit of a harder target that way. So there is some kind of, in my view, kind of other benefit to, again, although might not be perfect, there's other kind of benefit to if you're going to excluding by area code versus, say, IP geolocation. So that's kind of the spectrum where a lot of these discussions have been occurring and where a lot of people have been, kind of spinning, like, their gears have been turning around what we need to do in response. Again, there's no perfect answer here. Each kind of decision you might take comes with its own set of trade-offs as we've discussed. So with that is my kind of core overview of what we got going on here with this law. I'm going to turn it back over to Andre, and then I think after that it'll be time for Q&A.
Thank you, Artin. This was incredible. I know it's hard to digest. There's a lot to digest here, guys, but it's important. That's why we're going to record this, and you'll have a preview. And this is just a theoretical explanation, but there's a lot more behind it. Now, Amber, I'm going to answer your question probably in this slide as well. Thank you for posting this. So Referrizer built in and compliance and consistently adjusting. As we see the law changes, we want to make sure that you guys understand that, as we are a platform that helps you deliver these text messages out to the customers. Now, as very important part is, critical part, nothing will protect you unless you have opt-in data. And opt-in data is just mandatory. So yes, our pop-up, our widgets, our data capturing system do obtain, but also track and record every opt-in within the Referrizer automation. So we want to make sure that we allow you to capture that, and we allow you as well to properly opt in data with a proper language. Now, second part is opt out. The moment that somebody replies stop, we opt them out from the system, and it's hard-coded. You cannot even opt them in manually unless the customer explicitly send back message, subscribe, opt in, and so on. Because there's double layer. In the backend, in Referrizer, we have option to control subscription, but there's a layer that you don't see that's hard coding saying, no, you're not. So even from your own mistakes, we'll protect you there. Third thing is data retention. In case something comes up, you have data in Referrizer that we can extract for you that shows you all opt-in, opt-out data, and also shows the changes. how does person opt in, when did they opt in, which channel, and how did they opt out. It's recorded in our database. Why is this important? I'll give you one example. It's because of next thing, quiet hours. Because one of our clients, I'm not going to mention name, get a lawsuit that it was dismissed. But the lawsuit was very threatening. It was like millions of dollars. And it says, my client have a proof, message was delivered at 7:36 in the morning. And that's out of the quiet hours. Quiet hours are different for each state. So even if you have opt-in permission, everything's legal, you comply, you register, but you send them a message in the wrong time, you are putting your business at jeopardy. So a Referrizer have a system that if you send automation and automation goes for multiple days, it's going to protect you from sending messages out. But what happens in this case is that person have phone off for the moment that the message was sent. It was sent in the proper hours. But they turn on the phone and it's 7 o'clock in the morning, and that's where the message arrived. And they have a proper screenshot saying, this is when I get the message. For them, they have a proof. I got a message 7 o'clock. But because of this data retention layer that we have, we also had a proof that message was sent the day before in the proper timing. So it's very important to stay compliant. So, question for the CEO, Amber says, when people opt in to texting on our website using Referrizer pop-up with our offers, is there compliance that says terms of service? And if so, how can we as consumers update those terms to include arbitration and class action waivers? And there's other question from Boyan and Michael. So in our system for opt-in, as you can see, currently we have like offer, and there's a phone number, and there's agreement, and there's a terms of service. Currently we have terms of service, they're default. But if you want to modify this particular for your business, would love you to contact your support rep. Says, okay, I updated my terms and conditions. Can you put this into my app if it's specific to a Texas? So Referrizer wants to do everything to protect you from the technology side, but you got to do your part. Because not all the data comes through us. You have your CRM, you have your customer interactions, you have your data capture systems that when the customer signs up, you want to make sure that you have right legal language. And that's why we brought Artin here, so you guys can ask a question. And I'll ask Artin if that's okay to promote his information and to help you guys serve you as well. Now let's go to a couple resources and then questions. In this presentation, we'll be sharing with you as well everything. Like if you want a registration 3401, you will see that this is a beautiful, simple form that requires hundreds of questions, 7 pages of data, $10,000 bond, and oh my God, even notarizing everything that you're sending in. It's really complex. Now you have a regulation of telephone association and a couple links that Artin shared as well about what's going on, what's the fight back, what people are talking about this. So you can educate yourself. And before we go further, let me read a couple questions, Artin. And I'll read the questions and you can answer it to our audience. So Boyan asked, Artin, what is the other method to identify customers' location other than phone area codes? You use some acronym that I'm not familiar with.
Yeah. That was, again, this is just kind of based on talk that I've heard from clients as we kind of grapple through like different solutions, but it was IP geolocation. In other words, if you're logging, someone comes onto your website and they register and you're logging the IP address used at registration, that will then geolocate to a specific place. That's one data point that, you know, some businesses have kind of batted around as like using as a basis to suppress certain kind of segments of their SMS list in Texas. But for the reasons I've said, you know, I think there's other, you know, benefits that you can get from just basing that decision, that kind of slicing and dicing on area code versus IP geolocation.
Thank you, Artin.
Mhm.
Michael posted a question. For the 2-year in-state operation exception, is eligibility determined at a franchisor level or at the individual franchisee location level? Good question, Michael. Example, the franchisor is more than 2 years in state. the franchisee is new, who qualifies?
That is a very good question. I don't have an answer to that off the top of my head because that has some nuance there in terms of how the franchise or franchisee relationship works, whether or not if there's any sort of clarification or case law that addresses this particular issue. This is literally the first time I have encountered what seems to be a very well thought out and good question. I would be happy to, although I don't have an answer to this question, I just don't want to shoot from the hip on something like this. I would, I'll have my contact information at the end. Something we can most certainly kind of address offline because this is something that would just require a bit more of a deeper dive into the contours of that particular exception.
And this is exactly why we have here, Artin, and this conversation, because there's so many questions that, and so many gray areas in the same time, like not clarified definition, like what is the customer and many other things. So that's why we love having you guys here on the call and asking this question. Amber, yes, we are working consistently to update language. In some of the instances, we will be updating as a template. In some other instances, we will be notifying our clients what they need to do on their end. Because when there's a language changes, when there's offers changes, when there's certain things, for example, every state has different quiet hours. So we want to make sure that clients, our customers, Referrizer, businesses can go in the backend and change quiet hours so you guys comply. Literally, sometimes small difference can make a big impact here. Nicole, ask a question. If your company qualifies for exemption, do you still have to register?
No, you don't. If your company, in fact, 100% you fall within an exception, that's the whole kind of deal, right? Is that these are exceptions to the registration and some of the other requirements under this Texas statute. Obviously, you still, no matter what, right? Opt-ins, opt-outs is that like the nucleus of SMS compliance. But when it comes to Texas, yes, if an exception applies, then that is an exception to those rules we've talked about.
And I want to add to what Artin's saying. TCPA still applies to everybody. So that's a law that you still have to comply no matter what. Now, there are a couple questions from you guys who submitted during the registration for this event. And Artin, I'll read one at a time if you don't mind. So I think we already covered this. How do you handle existing clients versus new contacts under SB 140?
Yeah. I think it's just the same, right? Existing, current, future, past, like it's all, you got to handle all of everything we've kind of talked about applies equally to clients, contacts, potential clients, that we've discussed. So yeah, it's uniform across the board.
Another question. Can you still use SMS marketing to drive sales while staying in rules compliant?
So you can absolutely. I think it's just going to like what it takes to stay compliant is now a bit of a more complicated question. With Texas coming on the scene with this wacky amendment, in my view. But generally speaking, again, I think now that we've seen a lot of kind of automation and technological advancement and the opt-in and opt-out processes that businesses are able to use essentially off the shelf, I think that this really kind of aids in a business's ability to use what is a very potent communications tool while also staying within the bounds of the law. And obviously, like, just as with any other legal issue, some of those bounds can get fuzzy and there could be a lot of nuance there. But generally speaking, yes, like this is certainly something that can be accomplished while taking practical steps to minimize legal risk.
Awesome. Next one. And I'm going to be keeping an eye on your chat, guys. Does this include anyone from other states and countries with texting?
Yep. If you're out of this, like the key question is, are you texting someone in Texas? Doesn't matter where you're located, you're going to be subject to those laws. So if you're in Idaho or California or whatever, and you're texting in Texas, those laws apply. Even if you're overseas, same deal. Those laws are going to apply.
Arthur, I just want to say thank you on behalf of this audience. You're incredible in helping us understand this at a deeper level. As you guys are learning as well, I'm here learning the same way. So this is question comes from, I didn't put a name on it, but one of the people, and you'll recognize yourself. I'm pretty sure we're exempt. We are brick and mortar who has operated since 2011. I just want to know if you can still use Referrizer to send out a marketing text. Example, book this appointment today for $10 off. Or sorry, we missed you. How can we help? Or franchise opportunities available now. Click this link to learn more, etc.
Yeah. Yeah, good question. So that goes back to the brick and mortar exception. I'm just using shorthand to refer to that. And so just remember, it's you got to use the same name for the past 2 years. And again, I think someone pointed out there could be some nuance there in that analysis that would take a bit of a deeper dive. But let's just assume you check that box and you're making a majority of your sales. So 51%, let's just say, that would meet the definition of majority, or at least the common understanding what a majority is, out of that brick and mortar, right? So that becomes a pretty easy question if you're just offering like in-person services, like you have a spa or you have a studio where you're offering fitness classes, right? You're going to be doing most of your stuff out of your brick and mortar anyways. So yes, you can, caveat being, of course, that you have a valid opt-in, and that person has not opted out.
And I'll tell you one example, guys. We have a businesses who acquire other businesses and they change the name. They become part of the brand. And suddenly they send a message to everybody in the database. Imagine that customer who used to be part of one business is now getting a message from totally different business name saying come back and for our client appreciation without telling them that they acquire business, without any proper messaging. People go nuts. Imagine now even family relationship get ruined by saying, hold on, what? Like when wife see the husband went to certain spa and we want to welcome you back, like where did you go? What is this message? What are you going to do? We saw it all. So if you, or two businesses partner up, it's like, oh, let's promote each other. And they just blasted each other messages. Don't do unethical stuff. That's where the problems comes.
Andre, that's such a good point too. I think just more, I've used this word a lot because I do tend to like it, and it just kind of part of my philosophical approach is holistic, right? Like part of this also doesn't necessarily like your legal risk is also a function of just your overall business practices too, right? Because I'll tell you, I see two types of plaintiffs. Okay, usually you can put them in one or two buckets. Number one is the professional plaintiff grifter who goes on, specifically signs up to receive messages just so they can sue. Okay, those people exist. They're out there. I know a lot of their names because they keep coming up in these lawsuits. The other one is a pissed off consumer. Okay, because at that point your business has motivated someone to go find a lawyer, not just a lawyer, but a lawyer that specializes in this area of the law to come and sue you. Okay, so just from a more holistic basis, the lesser amount of pissed off consumers you have is just a numbers game, right? That in and of itself can perhaps reduce your legal risk for a lawsuit. And again, this is just speaking from experience handling many, many, many of these lawsuits for a good amount of years. So, great point, Andre.
Appreciate your comment as well. So somebody says, my business isn't in Texas, but what happens is if a visiting client books a class?
Yeah. Yeah. So, like, assuming this question is like, hey, I'm located out in California. Someone flies out from Texas, wants to take a workout class. They sign up, they opt in to take messages as part of the registration process. These Texas laws are going to apply to them, right? So kind of you got to make a decision, right? Like how many people from Texas are you trying, right? Like some of this stuff could just be like, look, it's just not even worth our time or the risk or the issues to text these people, and you just kind of set up a suppression that way, right? But just generally speaking, yes, like if you're located out of state and someone from Texas comes over to you, gives you their number, they're a Texas resident, then goes back to Texas, and now you're texting them in Texas, these laws are going to apply.
Yeah, very important to know. In your SOP, you can just say, hey, if you're not local, you don't need to put them in a database at all. Don't even collect opt-in. Don't subscribe them. Don't even initiate message. So another one, does registration ease off any TCPA measures?
Nope, totally different. It's a different state law that applies only to people you are texting in Texas. TCPA is a federal statute. Those apply independently of any state level requirements, whether they be in Texas or otherwise. Although on a Venn diagram, I'd say there's a good amount of intersection between a lot of the state laws and the TCPA, particularly when it comes to consent. So.
And guys, as we are wrapping up, we're coming to the end. I know there's probably a couple other questions that you have. And I want to say, Artin, appreciate you. Thank you for coming on a webinar today, for sharing your time with us to educate audience and business owners who are really looking for the answers. Your knowledge is incredible. And for you guys who are looking for advice, for help, either you're a franchisor, corporate, CMO, marketing person, or small business owner looking to stay compliant, Artin have graciously shared his email and a phone number and a LinkedIn. So, and I will invite you, if you need help, feel free to reach to Artin. My whole goal for me on this webinar is to introduce you to changes, to explain what they do, to answer your question, provide you value, so you know what you need to do, but also provide you with a resource. So Artin is here as a partner and as a professional willing to help you guys as well. So you can take a screenshot, or you can later on pull this information from the email. Artin, appreciate you being here. Thank you so much for your generous time, expertise, and on behalf of me and everybody on the call, thank you again.
Thank you. It was great being here. And yeah, feel free to reach out. Contact information below. Would be love to speak with any of you online. Thank you very much.